Senator Cloud has Senate Bill 482, provides for public records involving the security of government the governor or his family, and recommendations by the governmental, which governmental decisions and policies are formulated. Senator Cloud.
Thank you, Mr. Chair. I think I'm the guilty party. I think I ran Senator Morris out. He said, "Who's next?" I said, "It's me," and don't cut the line. So I'm sorry about that. I didn't realize it. Thank you, Mr. Chair and members. This bill does what you said. It addresses both the security of the governor and it protects deliberative process privilege. And in opening, I'd like to start by addressing the deliberative process privilege by citing a couple of court cases. Kyle versus Louisiana Public Service Commission in 2004, the First Circuit cited in their analysis that the deliberative process privilege is unique to government and has a number of purposes. It serves to assure that subordinates, staff within an agency, will feel free to provide the decision maker with their uninhibited opinions and recommendation without fear of later being subject to public ridicule or criticism. It also is used to protect against the premature disclosure of proposed policies before they have been finally formulated or adopted, and to protect against confusing the issues and misleading the public by dissemination of documents suggesting reasons and rationales for a course of action which were not, in fact, the ultimate reasons for the agency's action. They go further to say, thus, the privilege protects documents reflecting advisory opinions, recommendations, and deliberations comprising part of a process by which governmental decisions and policies are formulated. Then I'm going to move to the United States Supreme Court. In 2021, the United States Fisheries, Fish and Wildlife Services versus the Sierra Club. Again, the courts say, this case concerns the deliberative process privilege, which is a form of executive privilege. It further states that the same as above, that documents reflecting advisory opinions, recommendations, and deliberations comprising part of a process by which governmental decisions and policies are formulated. It states that the privilege is rooted in the obvious realization that government officials will not communicate candidly amongst themselves if each remark is a potential item of discovery and front-page news. That's the United States Supreme Court. So now, members, I'd like to entertain my amendment set 2094 to put the bill in the proper posture. If someone would offer that.
Secretary, I'd like to offer those amendments up. Can we distribute in those amendments? You want to go ahead and read in those amendments?
And I'm happy to explain those to you. So Amendment 1, 2, and 3 are just technical in nature to provide room for 4 and 5, which I'll explain. Amendment number 4, after some of the concerns that I've talked through with stakeholders, I wanted to add legislative intent so that there would be absolute clarity of what we're doing and why we're doing. We're basically codifying jurisprudence. And so first, in Amendment number 4, I want to read, if you look with me at A1, this is already statute. It says the legislature recognizes that it is essential to the operation of a democratic government that the people be made aware of all exceptions exemptions, and limitations to the laws pertaining to public records. In order to foster the people's awareness, the legislature declares that all exceptions, exemptions, and limitations to the laws pertaining to public records shall be provided for in this chapter or in the Constitution of Louisiana. This previous legislatures has said that we need to provide clarity. So if we move to 2A, this is my legislative intent. And I took this language from jurisprudence from the courts. It says the legislature further recognizing that protecting elements of deliberative process safeguards the process through which governmental decisions and policies are shaped and formulated, and that this privilege has been long acknowledged and upheld by the United States Supreme Court and various federal and state courts. This privilege fosters open communication within government agencies with their staff by allowing public servants to provide uninhibited opinions and recommendations without fear of public ridicule or criticism, and guards against public confusion by preventing the premature disclosure of proposed policies before they have finally been formulated or adopted. So if you notice the two cases that I read, it's nearly verbatim. We just formulated into this legislative intent. And if you move to amendment number 5 in an effort to provide more clarity, I've added that no provision of this section shall be construed to deny any person the right to observe deliberations of public bodies as defined by the Open Meetings Law, which carries a fine of $500 per person. So we don't want anyone trying to skirt around the Open Meetings Law. So that is what the amendments do, Mr. Acting Chair, and I ask for adoption so we can get back on the bill.
Thank you, Senator Cloud, for that great explanation. I see no questions on the amendment. I'll move favorably on Amendment Set 2094. See no objection. 2094 moves favorably. Back on the bill.
Thank you, Mr. Acting Chair. So again, I've said that this legislature, the previous legislatures, already statutorily acknowledged that the public should be made aware of exceptions and exemptions and limitations in revised statute 44-4. I want to move to the security of the governor. There is a provision within the bill that deals with the security of the governor. The bill proposed under Chapter 44 introduces specific exemptions regarding the disclosure of records pertaining to the governor, particularly concerning the scheduling and security details of the governor, his spouse, and his child. Currently, after a public records request, the way that law is currently, that those details could be provided to the public after a mere 7 days, which provides, nefarious figures from being able to recognize patterns within the governor's spouse or the governor's son's day. The bill delineates that the chapter will not apply to records related to the governor's schedule if they contain security details that could jeopardize the safety of the governor. This exemption is crucial to maintaining the security and safety of high-ranking officials and their families. I do want to say that the exemption does lapse after 8 years of the creation of the record, just like it is in current law. And back to deliberative process, basically, the bill addresses public records requests as they pertain to deliberative process, just as the courts have declared the exceptions and exemptions. So I did not make the definitions. The courts did, and by putting them in state statute, we're providing clarity to the public, as we've recognized as a legislature we should. And so without any further explanation, that's basically what the bill does.
We have several questions. We'll start with Senator Jenkins.
Okay. Thank you, Mr. Chairman. So, Senator, help me with this, okay? I read the bill. You amended the bill, and you brought a lot of information forth. So I'm just trying to make sure I understand. I think we all want the governor and his family to be secure. We want security for them, okay? So give me an example of what we said. When you say that, if we're going beyond just security for the family, what are we extending this to be? I see security for the family as one thing, and maybe, people who are reading this bill may see it as something different. I see security for the family, make sure you got people in place to make sure that no harm comes to the governor or his family, either at home or when he's out traveling or whatever the case may be, which is something I fully support. But are we expanding this now to something beyond just safety, personal safety, I guess is what I'm asking.
As far as security is pertained, we are not expanding it. The only thing we're removing is the requirement that after 7 days, when a public request has been made, as it pertains to security already defined in law, we're just removing that 7 days, and we're just removing that it doesn't have to be provided after 7 days.
Okay, so I mean, for people who are listening to this, just to get, I'm just trying to get some clarity. We're not suggesting in this bill that if the governor is going to go make an appearance or speech at some location, that is still information that can be publicized to the public.
Yes.
So we're not, and the reason I'm saying that because I received a lot of different calls, and I'm just trying to make sure I'm maybe covering some of what I thought people were concerned about. The governor's schedule, is that something that will still be available?
It will still be. This would just be data sensitive to his security, his wife's security, his son's security, and safekeeping.
Okay. Now, on the second part where we're talking about the opinions, recommendations, and deliberations, help me with this part of it a little bit. What exactly are we trying to protect?
We're actually, Senator Jenkins, all we are doing, it is as simple as this. We are taking the deliberative process privilege, conversations. I'll give you an example. If an executive has a conversation with their press department, and the executive says, I want you to put together a draft for a press release, and I want you to put X, Y, and Z in that draft for the press release. So the press secretary puts that together, sends it over to the executive. The executive looks at it and says, no, that's not what I said. That's not factual. Or maybe circumstances has changed. And that executive says, I need you to revise that press release because it's not the right information, and we don't want to disseminate the wrong information. So the secretary revises it. Right now, there's an assumption that they could prematurely get just a draft. And now the court said that they can't. The court said that is just part of a deliberative process, that is not a final work product. But there is an impression by some that they are privy to that information. And to put that information out prematurely would be disingenuous, misleading, and potentially catastrophic in some cases. So final work products, that final press release is fine. That is protected. It's a final work product, and it would be part of the public record. But anything prior to that, that's a work in progress, and it shouldn't go out to the public. Just like, Senator Jenkins, when the media is doing an investigative report and they have their sources and they have their tips and they spend time investigating their tips and the validity of their tips and their sources, we don't require for them to expose their sources and all of their data. They put out their final work product because otherwise it would be untruthful, misleading, and potentially chaotic.
So if there are and I'm just trying to really address what some concerns that was raised to me. So if there were text messages between the governor and let's say head of state police, for an example, about something that had occurred, would that still be made available to the press if they wanted to see that, although a final decision was not made by the governor as to which direction they wanted to go with an investigation?
I am not an attorney, but if it's something as far as deliberating on a solution to a problem, I would imagine that would be considered what's protected under the courts currently, not even whether or not we pass this. Whether or not we pass this, the courts have already determined deliberative process protections. So they've already
does it actually go to if the governor and I'm just using this example, if the governor and the head of state police had text messages with one another about something that had occurred, and the governor has not yet made a decision about which direction I want to go or what statement I want to make about this incident that we've had these text messages about. Are those text messages available for public inspection? Would that be available, or would this protect that? Is what I'm
Yeah.
asking this based on something that was asked of me.
That was asked of you.
Okay.
I mean, I would assume that it would already be covered under the deliberative process privilege, and if it was challenged in court, then the courts would look at previous jurisprudence, which would call it protected, although I'm not an attorney.
Okay, no, I understand. I'm not trying to hold you to that standard. I'm just trying to ask some of the questions about the concerns that I have. And I do want to understand this. I want to make sure two things. One, that the governor and his family is protected. I definitely want to see that. And at the same time now, on the decision-making process, I'm a little concerned there as it may relate to what information should be made available, because there are a lot of things that do not come to light without the press or other people being able to go in and request this information and bring some of this decision-making process to light for people to see. So that part of it, I'm going to still need to kind of, go over in my mind a little bit, but
Yeah.
I appreciate your answer.
And I think, Senator Jenkins, it would be of greater concern if the courts haven't had firmly established jurisprudence in the matter of deliberative process privilege. I mean, we're not trying to find the remedy. They've already established their stand on it time and time again. So we're just doing what the legislature has said in revised statute 44-4, which is to foster the people's awareness that the legislature, any exceptions, exemptions, and limitations pertaining to public record should be provided in this chapter. And that's already provided, that path is already provided by the courts.
And one last question. So if this bill appears to be directed to the governor, so what is to stop any other statewide elected official from seeking the same protection? Or should they be entitled to the same?
Yes, sir. The security is pertaining to the governor. The deliberative process privilege is pertaining to all government agencies.
So that's something to consider. Okay.
Yeah, but we can't erase jurisprudence. That's the thing. That we tend to forget. Like, the jurisprudence is there. The United States Supreme Court has already ruled this. We're just putting it in statute. So, hey, and 30 other states, that's over half of the country, have deliberative process privilege in their statutes. That's over half of the country. So,
All right. Thank you for answering my question, Senator. Thank you, Mr. Chairman.
All right, thank you, Senator Jenkins. Senator Reese.
Thank you, Mr. Chairman. Senator Cloud, not to put you in the position of working in the administration necessarily, but I do know you have a lot of background and knowledge in this area. Your bill is effective August the 1st of 2024. So how will the release of information change on August the 2nd if your bill passes differently than the release of information today?
that is a great question. It will not change.
And that's what I assume, that essentially the interpretation of the current laws and court rulings being applied by the administration today, and the release and the review of information to qualify it for release, and the standard by which they would measure that after August the 1st you're saying would be the same, essentially.
It is the same. And I think that I think you might have some cards here, Mr. Chair. There's, I think, Miss Catherine Newsom. She used to be the state archivist. She could provide some clarity as well.
Okay.
To that
Well, I look
question.
forward to hearing from others on that topic too, but I just wanted to clarify that point based on some of our prior conversations, that I thought that you were not attempting to disrupt the process of release. You were attempting to streamline.
That's right. But it
the application of that.
sure sells newspapers, though, the premise of that.
Yeah. Thank you, Senator. Thank you, Chairman.
All right, thank you, Senator Reese. Senator Carter. I don't know why it's always hard on your, but
I don't know what you got against me, Mr. Chairman. Senator, I'm studying your bill. I've been reading it. Do have some questions.
Sure.
If the current jurisprudence is that the deliberative process exception, or if that privilege exists, can't a lawyer for the governor or any government agency just submit that as a privileged reason why the information should not be provided? That we don't need the legislation; the lawyers can already assert that privilege.
Yes, that is completely true. But then we probably should erase from our own statute where the legislature has said, in order to foster the people's awareness, the legislature declares that all exceptions, exemptions, and limitations to laws pertaining to public records shall be provided for in this chapter. Because previous legislatures have said people deserve to know the rationale and reasons why. So when someone requests a public record from, say, the Secretary of State, and the Secretary says, no, we don't have to provide that information, and then they reach back and say why, and then the Secretary of State sends like 3 different case laws, you have the average Jane or Joe trying to read 3 different case laws when we should just follow our own rules and put the privilege in statute.
Let me ask you this. Could this be a shield that can prevent any executive from producing information by just saying or claiming that a decision hasn't been made? Going back to the hypothetical that Senator Jenkins gave you, that the governor says he has a text from state police regarding some issue, and the governor being able to say, well, I haven't made a decision yet, and therefore the information should be shielded from the public. Do you see that concern?
No more than it already is, because I think that question would need to be posed to the courts, because the courts have already answered that question.
Well, I'm concerned, and let me give you a real life example of why I'm concerned. Part of the process that we're going through now is figuring out the Constitutional Convention. Isn't it fair for the public to know what's the pre-decisions that went into the framing of the Constitutional Convention, who may have been meeting with the governor, who may have been meeting with agency heads, what interest groups may have been a part of the conversations? And under this statute, the governor, all he has to say is, well, I haven't made a final decision regarding the Constitution, so therefore, who I've met with, the pre-decisions, the thought processes, the recommendations, the candid discussions back and forth are shielded from the public.
I would say
and from us as legislators.
I hear you, Senator. I would say that rather than saying under this statute, I don't have to provide this and this and this, he could simply say under Kyle versus Louisiana Public Service Commission in 2004, under the 2021 United States Supreme Court in United States Fisheries and Wildlife versus Sierra Club, 2011 Department of Insurance versus the legislative auditor. He could just do that.
Right. And if he did that, it would then go to a judge to determine whether or not that's a fair use of the privilege. There will be some oversight. It will be the judge saying whether or not this is, in fact, privileged information or whether or not this is information that should be made public. Your legislation will remove that judicial oversight part of it. Do you see that concern?
No, I don't, because they still have legal remedy if they feel like they've been unfairly treated.
We received an email listing, possibilities regarding the Constitutional Convention. Article 1, whether or not there'll be suggested changes to it. Because those decisions haven't been final, is it your position that how the governor arrived at what should be changed, what should not be changed, should that information be made public, or would that be shielded under your statute?
Yeah, I don't know, Senator Carter. I mean, to ask me for my opinion on all different things, I don't know if that's a fair thing to do, because I'm being asked for a spot, like on the spot.
I'm not trying to put you on the spot like that.
What I'm doing with this legislation is relying on several years of court rulings, all the way up to the United States Supreme Court, and that's where I want to stay, not guessing at what my opinion would be on this, that, and the other.
Well, the problem is, though, that and I'm just expressing a concern. When I look at the security piece of your legislation, I understand why that's there. But when I look at the second part of it, to protect from the public pre-decisions made by an executive, that's where I have concerns. I think the public should know how decisions are being made, especially on important matters. And I just don't think it's proper to be able to say the governor has a right to not be able to share how decisions were made, what advice he sought, what was those recommendations he either accepted or didn't accept, as opposed to just informing the public this is the final decision and all public records can just relate to that final decision.
Yeah, I just look at, under certain circumstances, I completely agree with you in, public transparency and public interaction with government. I agree with you completely. But again, I arrive back at there is executive privilege and there are there's court jurisprudence that already, we're not doing something new. It's already provided for by court jurisprudence and executive privilege that's rooted in the Constitution.
Yeah, I'm aware. And also dealing with the issue at the federal level. Let me read you something. This is on the Department of Justice's website regarding this specific privilege. And this is what it states. And this is in reference to the Sunshine Act that the U.S. Congress passed in 1976. It is hereby declared to be the policy of the United States that the public is entitled to the fullest practical information regarding the decision-making processes of the federal government. And that is 5 U.S.C. Section 552B with the formal comment note confirming that. This seems to be going against that grain.
But it's
because
not.
This statement in the Sunshine Act specifically talks about providing information regarding the decision-making process of government. That is important for the public to know.
Yeah, it's also important for the public to know that this nearly mirrors the federal provisions, the way that federal agencies operate as far as deliberative process privilege goes. So they have and exercise deliberative process privilege in federal agencies. And there are people that are in this room that are probably much more educated and experienced in being able to speak directly to that. But I can tell you that I know that we are mirroring in many ways what federal agencies already do with the deliberative process privilege.
And regarding that, what federal agencies do regarding that privilege is there's a checklist before the privilege can be asserted by the federal government. And it's a list of 12 separate items before a federal agency can assert the privilege. To the extent your bill deals with security, I'm open to that issue. Regarding the decision-making process, I have concerns, but I'm going to hear and listen to everyone else.
Yeah, and I will say I'm going to continue to work through this. I mean, I am a lover of government, and for people to be able to be involved and educated and we don't want anyone to feel like they're being shut out, but we also don't want them to be misinformed.
No, and I'm glad we were able to talk about this before the hearing started to give me an opportunity to look at the cases and things of that sort. But to the extent we're talking about security of the governor's family and the governor himself, I think we all are sympathetic to make sure the governor's safe. But when it comes to the decision-making process, how decisions are made by government, we're people of the government, so the people need to know that. So
And
those are my concerns.
We're very blessed, Senator Carter, in the legislature because we exercise this privilege every day. We have legislative privilege that protects our deliberation, and so that's in statute, but yet other officials.
I agree with you, but just let me say this on closing, though. We do have a lot of information that come to us that most people don't receive. But when it comes to information like around the Constitutional Convention that's being proposed, many of us feel left out. Senators, representatives feel left out. So imagine how members of the public must feel if they have even less information than we have, and we're hearing reports of drafts, we're seeing suggestions. That's part of the decision-making process, and that's the sort of information that it'd be my preference that information is readily available to the public, which is consistent with the statements of Louisiana law as well as federal law. Thank you, Mr. Chairman.
Thank you.
All right, thank you, Senator Carter. Senator Miller.
Thank you, Mr. Chairman. Senator Cloud, the bill obviously has two separate components dealing with the governor's security piece as well as the communications deliberative process. And obviously, we support making sure that the governor is safe as well as his spouse and his family. And of course, we already have a provision in the law dealing with that, and it has to remain confidential for at least 7 days under current law. But I understand your concern and the bill is trying to address is that somebody can then analyze after 7 days the patterns and practices about this. But the other thing that your bill does, and my question is, why is that there's a specific, you're repealing 44.5 dealing with that, the particular of that, it says that nothing in this paragraph shall be interpreted or construed in a manner to make confidential all records concerning a meeting or event that the governor attends and transportation related thereto. So it seems to me by repealing that and putting this, you're saying now, and we at the legislature, if we pass this legislation, that that any of these records could possibly be made confidential about whatever meeting the governor attends and the transportation related thereto. I mean, is that the intent of your bill?
The intent of the bill is to protect the governor, his son, and his wife from any potential risk or harm.
And so to protect the governor and his spouse and his son, we're saying that the public will have no ability to get any of these records dealing with transportation or meetings that the governor attends.
The governor's been very transparent, Senator Miller. In fact, if you just look at his social media, you could probably pick up nearly all the meetings.
No, and this isn't aimed at any particular person. We're talking about an office because this may be, if this is the law, my question is that is an implication, and I just want to make sure that we're aware by repealing that B4 and substituting this section 64 on page 1 that's what's happening. But the next part is the deliberative process. You want to codify what you're saying. So the question is, and you may have answered it, I'm just trying to get it clear that if it's already jurisprudential, then why is it necessary to put this in?
I feel like I keep going back to because we said we should. Because the legislature said we should. We should, for public awareness, let people know what exemptions, exceptions, and limitations to the laws pertaining to public records are. The previous legislatures have long established that we should let people know. So right now, Senator Miller, as I said earlier, you have a Jane Doe wanting a public record. She sends something over to an agency head, and the agency says, "These records, we're not able to. We don't have to provide these records." And then they reach back and say why. You should provide them to us. And then they send case law to Jane Doe, and Jane Doe's trying to sift through all the case law. Well, we said in previous legislatures to foster public awareness, we should let them know what limitations, exemptions, and exceptions there are in statute. We said it.
And this, and dealing with the deliberative process, this doesn't just apply to the governor's office or the executive branch of state. It's going to go all the way throughout. So it would apply to our parish president and our parish of St. Charles. It would apply to the city council and mayor of the city of New Orleans, or the RTA and those issues where they're paying money. How do they arrive where, we'll possibly shield how they arrived at paying someone money on in excess of a contract in violation of public law. So that may be swept under this provision.
Yes, sir. I want to move to, then that's something I wanted to be very cognizant of as it pertains to the financial matters. In 44.5, it says that this section shall not prevent any person from inspecting, examining, copying, or obtaining electronic or physical reproduction of any record pertaining to money or monies or assets or items of economic value or any financial transaction in the control or handled and that's in 44.5. And so what I asked was to potentially have an amendment to put into my bill to make sure that everybody has extreme clarity that they can still get all records of, financial matters. And what I've been told, and I may end up adding it to the bill moving through the process, but what I've been told is it's clearly established in law. Now, if we need to make it clear in this bill, I'm good with that too.
Well, it's not just about the money, but sometimes it's how did the government end up with this contract paying this person, or end up hiring this person for a contract, engaging in that. And you know what? I think the public does have a right to know some of those things, and we need to be very, very careful about being overbroad in granting these types of exceptions. I mean, give you an example. St. Charles Parish is a plaintiff in a lawsuit in federal court against FEMA with the risk rating 2.0 map, which we're told that we cannot get the information about how they determine what these rates are that they're imposing, and people are having to pay. We've already got the property insurance, but in these areas where we have to have flood insurance, we've got these flood insurance rates that are just accelerating. And we're suing to try to find out the deliberative process, how we arrived at that. And to be able to, I just want to make sure that we're not taking that ability away for legitimate concerns of against the government, and taking away the freedoms of our voters and our electors and our Louisiana citizens, or whoever it is, because we just got to be very careful about this. I know that you are a proponent of freedom, but also I understand the abuses that can be led to, and we need to make sure that we're not abusing the Freedom of Information and the Public Records Act. But thank you very much for answering my question.
I agree with everything you said, Senator Miller.
All right, thank you, Senator. Now we have one other person. I think it's Tony Jones who wished to be heard, who's in favor of the bill. If you come forward, we have several other cards in support, but do not wish to be heard for the purpose. All right, Vicky is Mills? Millis. You wish to be heard?
I have a statement from the Senator.
You have a what?
Statement.
Please come to the mic. All right, please proceed, sir.
Mr. Chairman and members, I'm Tom Jones from the Attorney General's office. I've put in a green card to indicate the Attorney General's support for this bill. The Attorney General, as much as anybody, understands the necessity of deliberative process. I'm a frontline guy. I work on opinions. I work on litigation. When I work on those things with other people in my office, I send memos to test whatever theory they've advanced for a case, for an opinion. The memo may be playing devil's advocate. It may be something I wouldn't ordinarily have written, except to test their opinion. Is their thinking right? Is their thinking wrong? What is the extension of it if you extend that thought? If I'm not protected by deliberative process, I'm not writing that memo. I'm not going to put it in writing. I'm not going to test their theory. I'm not going to check it out. I'm going to let it go because I don't want that document appearing in the public. If this bill is passed, the deliberative process part, the instances that have been mentioned by Senator Jenkins, there's a text from state police as an incident's occurring. Mr. Sternberg's office and mine are going to fight over does that item come under the statute, just like we would fight over it now. But we have a statute. It's clear, it's definite, and it's in the law. And the legislature has passed it, which makes it different from a court judgment. The legislature has made a pronouncement, and that's why the AG supports the law.
All right, thank you, sir. Please identify yourself for the record, and you may proceed.
Vicki Milius with Lieutenant Governor Billy Young-Gester's office. He was not able to attend today, but asked us to come give a statement in his place. He is at a meeting today in Jefferson Parish. However, he fully supports Senator Cloud's proposed legislation and wants to assure you all of his position. He strongly feels that it's important that staff members feel comfortable sharing their opinions and recommendations with him without concern. Open discussion is critical to decision-making processes, and all opinions should be considered and evaluated. He is a strong advocate for transparency and believes that final documents and agency decisions should be made accessible.
All right, thank you very much for representing the Lieutenant Governor. All right, members, we have several cards in opposition. We're going to take them three at a time. I have purposely held all three of my bills to the end, but other members have 1 o'clock meetings, and we have not given them any time to take a lunch break. We're going to call up first Rebecca. Is that Monterey? With the Bureau of Governmental Research, and Lee Zurich and Chris Nakamoka. The three of you all can come.
Yeah, can we let Scott go first?
Can Mr. Sternberg go first? Mr. Chairman, I think they're all.
Please have a seat. Bring whomever you want to come up. Just come in and come up and have a seat, and let's proceed.
I apologize, Mr. Chairman. Scott Sternberg, Louisiana Press Association. I'm the guy that got name checked just a second ago. I cannot sum up into words how much this will change the lives of citizens in this state. This bill is not the codification of federal Exemption 5, which federal FOIA provides in Exemption 5 for deliberative process pre-decisional until the decision is made for the executive branch. So not local water districts, not every town and municipality, not school boards, not libraries. The Kyle case from 2004 has one line that says that the deliberative process is a part of a district court decision in Washington, D.C., not even a federal decision, a state court decision in Washington, D.C., it cites to, and says that as a part of the attorney-client privilege, there is a deliberative process privilege. Now, I talked to the Attorney General this morning, and I think we all agree that there is a deliberative process privilege for certain items. It is in the governor's bill. I mean, it's in the governor's 44.5, a statute which a lot of the members here, the senators here, helped write in 2011 or 2015. The idea that because the United States Supreme Court has upheld the federal FOIA Exemption 5 as it relates to the executive branch of the federal government, and that is binding on you somehow is incorrect. And I do not think that there is any journalist or citizen who will tell you here today that they have had their public records request denied for deliberative process. I do this for a living. I haven't done it. I haven't seen deliberative process since the Jindal administration. And these gentlemen right here are reporters, and they're going to get up here, and you can ask them, and they can't lie. They're under oath. Let's talk about what this is really about. This exception is a repeal of the public records law. What document is not a part of the decision-making process of your local government? These are our tax dollars, my tax dollars. Build a road. Well, that's a government decision. We're going to do that. Okay. Let's put a stoplight up. That's a government decision. The big difference between this exemption and all 30 states And Senator Cloud's correct. They have it in 30 states, but it's not this broad, and it's always pre-decisional. So that means that when the decision's made, you get to see how it was made. That memo about the Constitutional Convention, we're not getting that if this bill passes. And look, I might be out of a job, but I really care about people being able to see what their government is spending their money on. That's what this is about. The Public Records Law was written so that the people, including the people on the dais here, can keep the government accountable. And if we were talking about a limited deliberative process privilege, I might not be so angry. But the amendment that was put on this bill just now is a fundamental change to the Public Records Law itself. It is a totally different bill aside from the deliberative process bill. So now we've got two really, really tough things for me to talk about. I would ask you desperately to vote against this bill. At the very least, defer it so that we could try to figure this out. But I don't know how to fix repealing the entire Public Records Law. This state has to trust that its government is spending the money that we give the state in our income taxes and our sales taxes. And your local government groups, the good government folks that you love, all those neighborhood groups that you go to see, when they figure out that they can't get tax exemptions anymore, when they figure out that they can't get the email between the mayor and the mayor's assistant where the mayor sexually harasses the assistant, never again. I cannot overstate, and I could not be more, you all know me, most of you know me personally. I don't get up here and tell lies. I tell you what it is. I could live with deliberative process. This ain't it.
All right, thank you very much, sir.
Unless you all have questions, I'm sure you don't.
There are questions.
A lot of the people got to testify. The chairman wants to go. So I'm
No,
to move on, sorry.
I
To
don't
move on,
want to
sorry.
lose these folk because I have 3 important bills.
I understand. I understand.
All
Chairman.
right,
I didn't want to-
it's Senator Jenkins.
Yeah, and I was waiting for you to come up.
Yeah, I was dying to come
And
up.
you are, well, and you didn't disappoint. So,
Sorry.
No, I said you did not
Oh, I
disappoint.
thought you said I did disappoint.
You did not disappoint. So here's what I'm trying to find out. Because, I look at the bill and I understand what Senator Cloud is trying to do.
I do too.
And I really understand what's being proposed, in the first part. And once again, let me just reference again. When we start talking about the governor, we talk about the office of the governor. That doesn't make a difference if it's Jeff Landry, John Bell Edwards, who comes next.
Absolutely.
And security for that person and for their family, to me, is important. It just looks like we got 2 different objects taking place in the same bill. It's problematic to me. I really wish I could vote for part of it and hold up part of it. I just don't know how that works. What would be, just in your opinion, as to the second part where we're dealing with the deliberative process, what would you suggest, being in the role that you played all this time, how we could address this in some way where some balance could come to it? Or can it be fixed? I don't know.
I have tried to work on this bill, and we have not been able to. The deliberative process itself could be put into statute, like the 30 other states, and Exemption 5 for FOIA. We already have it in the governor's statute because the governor needs to be able to talk to the governor's executive council, policy director, and not worry about those communications making them embarrassed, I think is something Senator Cloud talked about. I think that's totally legit. But part of the deliberative process problem is trusting the government, right? And I think that we have to figure out what level Louisiana citizens are willing to go to. I don't think that people should be scared to put things in writing. I'll say that. But I think that there is language in those 30 other states and in federal FOIA that we could look at and come up with.
Okay.
And I think this is actually a 3-object bill, Senator, now, because the amendment to 44.4.1 overrules every case in the last 60 years of public records jurisprudence for fun. So
Yeah, there are multiple
I'm
objects.
sure that was not the intent.
Right. Yeah, there are multiple objects in the same bill, which is another issue, that probably need to be talked out and looked at. But now, I just want to try to get some idea of if it's what was worked out in maybe some other states that could give some relief here, but at the same time make sure that we have some balance with
And Senator Jenkins,
public assets.
as somebody who deals with local government all the time, I totally agree that people should be able to have discussions. I just don't know that the library board should be able to exempt every single discussion. We got some people really mad about libraries in this building. They're really not going to like this bill when they figure it out.
All right. Okay. All right. Thank you, and thank you, Mr. Chairman.
One quick question.
All right, Senator Carter.
I apologize for being
No, one follow question.
Late night, y'all.
You made
Late
a
night.
good point. We're all addressing our questions about the governor, but this bill is way broader than just the governor's office. It would apply to local governments. It would apply to school boards. It would apply to library boards, universities, all.
LSU.
I'm sure there's
You
a
never
big
get
list.
another LSU record again if this passes.
I'm sure there's a big list of all of the public agencies, but this seems.
Senator,
continue.
because there is no limitation, it applies to every public body in the state of Louisiana without exception. The federal FOIA that we were citing earlier as precedent, which it is not, only applies to the executive branch of the federal government, the president.
And this proposed legislation applies to all branches of the state.
Including you, Senator, yes. Might not.
Yeah. Thank you. Thank you, Mr. Chairman.
All right, thank you, Senator Carter. All right, let's have three up at a time. We got 13 people wish to be heard in opposition to the bill. We've heard from one. Please identify yourself for the record, and you may proceed.
Very good. My name is Rebecca Mowbray, and I'm the president and CEO of the Bureau of Governmental Research. We are one of those good government groups that looks at government finances that Scott was speaking of. For the past 92 years, we have been working to make local government more effective, fiscally responsible, transparent, accountable, and responsive to citizens by proposing solutions to some of the biggest challenges facing the New Orleans metro area and working constructively with public officials to see these changes implemented. Our work to inform citizens depends on access to public records. We can't do what we do without them. We are deeply concerned about Senate Bill 482, especially the section that would shield the deliberative documents from all governments from public view. If Senate Bill 482 passes, it would be much more difficult for BGR and similar groups to research public policy issues and to serve the public because our access to documents would be limited if government officials didn't voluntarily cooperate and share them. Citizens will lose out if this passes. It will be very difficult for public policy researchers, historians, and biographers to understand how decisions were made. The process is often part of the story. Moreover, limiting public access to information will feed distrust in government, making the job of public officials everywhere much more difficult. For all of these reasons, the Bureau of Governmental Research opposes this bill. Please stop this deeply flawed legislation. Thank you for your time. On to Lee.
Thank you. My name is Lee Zurich, anchor and chief investigative reporter at WVUE Fox 8 TV in New Orleans. And, journalists don't often come here to speak in the legislature. Usually we cover it. So I hope y'all realize how serious and significant this is to us in transparency and accountability, that you have journalists up here who are coming to speak, because this is as serious as Scott said it is. This is that serious. The author of this bill talked about how the press, we don't have to disclose our, communications or different things and stories. Well, there's two differences. First of all, we are protected by the Constitution, but secondly, we aren't funded with public money. This is taxpayer money. This is your constituents' money that we are talking about here. I file an average of about 450 public records requests a year. Have been doing this for almost 20 years now. If this was existing law as was stated, there are some great attorneys in the state, some smart attorneys up here. Someone would have used this in one of those 450 responses a year, and I have never heard anyone claim this at all. As Scott said, it is not existing law. we've done so many stories on government corruption, abuse, and things like that. If you pass this law, we will not be able to serve as a watchdog like we have done before. In 2020, we did a series of stories in the Hard Rock Hotel in New Orleans. It collapsed. People died. Our stories show the inspectors from the city didn't show up. They failed to inspect the site. Many of the records we received in that series of stories may not be available now if you pass this law. Many of you have heard of the New Orleans Sewage and Water Board. This isn't just about money. What if we want to see a decision about why did the Sewage and Water Board not turn on a turbine? Why was it not working? What was the process there? If you pass this bill, we won't be able to see records like that. We put a sheriff in St. Tammany Parish, a DA in St. Tammany Parish. We've shown a Section 8 coordinator paying a six-figure salary, defrauding taxpayers by living in Section 8 housing himself. All records potentially and likely we wouldn't be able to get if this law is passed today. This isn't about clearing up the law. This is about blocking the media and, more importantly, blocking your voters, your constituents, from accountability, from accessing records that they owned. They fund it. If you vote for this bill, you're voting against transparency and you're voting against accountability. You're not voting to clean up the law. Thank you for your time. I appreciate it.
Thank you, sir.
Good
Chris,
afternoon,
good to see
committee
you
members.
again.
I'm Chris Nakamoto, a national investigative reporter with Investigative TV, Investigate TV. Prior to that, I was at a local TV station here for about 17 years. Thank you for taking the time to listen to all of us about this important bill. As Lee said, this is not something that journalists typically do. We never want to become the story, but we feel like we have to let you guys know what this would do to the state constitution and basically just be devastating to all of us. The language in the bill, part of the process by which governmental decisions are formulated, could easily be interpreted to encompass all government functions. It's intentionally vague, intentionally broad, and I've never seen anything like it before. I foresee it being used to block nearly all public information from ever being released. It's going to overburden the courts, an already overburdened system. I have two examples. In 2016, I was covering a local mayor about 15 miles from Baton Rouge. We had submitted a series of public records requests, and I was arrested because they didn't want to give up those records. It was about a pay raise that he had funded for himself. The records were ultimately released and showed exactly what the mayor did not want us to see. He was convicted over what we exposed and is no longer in office. But if this bill were to become law, it's likely we would never have seen those records. Another example, and I heard some of you guys up here asking about it already, is some of the state police stories that we have exposed. A public records request we submitted pertaining to Ronald Green up in North Louisiana showed top state police leaders were colluding over emails about his death and what caused the crash, whether or not he died from the crash or whether or not he died from the abuse. And they said that in those emails, they had proof to show that he died from the crash. Well, obviously, body camera video painted a very different picture. And when those emails came to light, it showed exactly what was happening. Other records showed Governor John Bel Edwards was also briefed about the death within hours of it happening. It was a complete reversal from what he had told the public prior. If this bill were to become law, it's likely those records would never have been released. The overly broad nature of the language could result in every records request, as I said, ending up in court. This bill does not foster transparent government. It's not transparent to the constituents you represent. And it's not transparent for the investigative reporters responsible for accurately reporting on how government functions. I'll ask this rhetorical question. If this was the prior administration, how would you guys vote on this bill? It would be imprudent to let this pass through committee.
All right. Thanks to each of you for coming. The board is clear. We'll now take.
So sorry.
Okay. Please identify yourself for the record, and you may proceed.
I'll go first. Ladies first.
Please.
First of all, I want to appreciate all of you senators for allowing us this opportunity to speak in regards to this bill. You have already heard some.
Identify yourself for the record, please,
Yes.
ma'am.
My name is Belinda Parker Brown. I'm with Louisiana United International. We are a civil, constitutional human rights organization for good government. And this, you heard one of our media speak about St. Tammany Parish. Had this bill been in place, we would never had the opportunity to get the media's attention because our organization do our own internal investigation through public records requests. And that's how we got the media's attention to verify the factual information that we had gotten through public records. I want to say that we do not need this bill. It is not about the governor's security. It is about public scrutiny. And to all of you, if you are elected officials, you cannot be afraid of public scrutiny. And we as citizens, as people that is concerned about good government, especially here in the state of Louisiana, where we are known for cover-up, it's public records that I'm still waiting on. It's already very difficult to get public records. Okay? So, I want to say that strike this bill, SB 482, and we cannot allow Louisiana to be at a risk of violating the Louisiana state constitution, because that is exactly what this bill would do. So on that note, I want to say thank you for allowing me this opportunity to speak.
Thank you very much for coming, ma'am. Please identify yourself for the record.
Stephen Procopio, the president of the Public Affairs Research Council of Louisiana. PAR was founded in 1950, and a large part of that was because of Governor Earl Long and the difficulty of getting any information out of there, including legislators couldn't get information out of them. And there were a bunch of citizens and citizens groups that said, you know, something needs to be done about that. And we have been a champion for public records since then. We have put in a red card on this bill, and we try very hard not to do that and make that very limited. But honestly, if I had the option to put in 5 red cards, I'd do that. This is a serious problem. And I don't doubt the intent of the author in trying to codify deliberative process. And I do understand the need for deliberative process. And there are current protections in law for deliberative process for the governor's office. But what this does is it takes a line from a decision about deliberative process, and it removes it from the context and all the jurisprudence that follows it and all the tests that have to be done, and it puts it in here. So no longer would you have to go and say, okay, look, here are the qualifications met, here are the case and the facts, and in this case, deliberative process should exist. Now it's just this, hey, records that reflect advisory opinions, recommendations, deliberations, they're not allowed. So deliberative process goes out the window, and it's just the lines in law that become what the criteria is. And so all of the other case law that can protect the citizen's right to know are now gone. So you're missing things like a timeline. So after a certain amount of time that they would be allowed. That's not in here. You're missing final decisions. So you're like, oh, look, this doesn't say once the deliberations are done. It says anything related to deliberations are now protected and off limits. It also doesn't take any boundaries in terms of, well, okay, is it just the governor speaking to his staff? It is an example, which is protected now. But if now you have interagency discussions with a government agency and a nonprofit or business, because there's no boundaries here in terms of, it doesn't say deliberative process, it just says anything that's going to affect a process by which decisions are made. I want you to imagine the next time, and it's unfortunately a matter of time before we have another major disaster. And people want to know exactly why decisions were made, why resources were deployed, and then they're not getting answers, and they come to y'all, and your answer is, well, it's a deliberate process, it's in the law. And they're not able to find out why decisions were made in a disaster. I pity y'all when that happens. I would like to be able to find something that could work, but I don't think this is the instrument to do it. I'd be happy to work with anyone, any authors, including the author of this bill, between now and the next session. But I think there are far-reaching consequences, because this isn't just the governor's office, as was stated. This is every state agency, every local agency, the Sewage and Water Board, anything that exists. Now this very broad language would apply to all of them. It is a serious problem. Thank you very much.
Thank you, sir. Please identify yourself.
My name is Bishop Freddie Phillips. I represent Louisiana Auctioneers, Professional Association of Auctioneers, but I'm also here because I've seen a lot, I've heard a lot, and I've been a part of a lot. Things that happen in Louisiana state government. I've been around from the earlier days of Jill Newman, Press Robinson, and guys of that nature from the north side of Baton Rouge. And I put in a lot of FOIA requests on privileged information that I would not have gotten, just like y'all passed out that amendment paper. Well, I felt that I was lacking the privilege of knowing what was on it because I couldn't read it. I mean, it disturbed me that introduction of bills that we have to make decisions on were not given to us prior to. And then you got to look at the political chicanery of the equation that happens as a result of that. I mean, right now, you're trying to take away the privilege of the public and make it private, when nobody can access that information at any time after, if this bill is ever passed. I mean, there were things that I discovered by FOIA requests that I would not have known had I not had the privilege to do so. So what I test is the intent of the heart. If you have no wrong and no guile in you, then what do you have to hide from the public? I mean, we are all, I'm a pastor, so I scrutinize my life every day. I swim against the current every day. And I look at myself to say, would I want someone to know something about me that I don't want them to know? Well, don't do what you don't want them to know. You won't have to worry about them knowing what you do. This is what it seems like. It's trying to protect someone from getting exposed. Yeah, I don't know all the deals that go on behind closed doors, but I know a bunch of them do. And I don't know what's legitimate and what's not legitimate. You know, I've been knocked out of the circle because I had bids out there and I just felt like I was undermined. But if I don't have the Freedom of Information Act to be able to pull that information and see whether or not it was valid, then I feel like I'm being slighted. You know, the big fish swallow up the little fish and nobody gets a chance to eat at the table, because that's what it sounds like here.
All right. Well, thank you very much, Reverend. Thank the three of you all for coming. We have Billy Broussard, Bruce Rowley, and Kevin Kissel. And we have three more after that, and then we will close on the bill. You can leave it there. Please identify yourself for the record.
Good afternoon, Senators. I'm Kelly Kissel. I'm the managing editor of WBRZ TV. Prior to that, I was Associated Press news editor in Arkansas and Oklahoma for 24 years and retired from the AP after 34 years. I'll ditch my prepared remarks and just tell you one anecdote. It has to do with LSU football, so I'm sure I have everybody's attention. In 1984, or prior to 1984, LSU actually would pay WWL in New Orleans to carry LSU football games on Saturday night. It was not seen as a valued product, and LSU was actually losing money for its football operations. Through the Open Records Act, I was able to obtain through the LSU Chancellor's Office correspondence which showed later that the athletic director wanted to open a bid process, but didn't really had some friends with whom he wanted to work, and found a system in which which he was able to essentially negotiate a contract one-on-one. The correspondence showed that the chancellor found out about this, did not like that it was happening in that way, and believed at the time that if LSU had actually gone to a formal open bid process, it would be able to collect more money, which is in fact what was adopted. If this law becomes, or if this proposal becomes law, finding out things like that will not, will forever be shuttered from us, and things will be hidden from the public eye. And so I would urge the voting against 482. Thank you.
Thank you.
Thank you, Mr. Chair. Members of the committee, Bruce Riley, Deputy Director of Vote. I just wanted to remind everyone how much we rely on people like this and the journalists who came up and the work that they do to find out what's going on, because some of us, whether it be, an organization like ours or elected officials like yourselves, take action based on what it is that they reveal. And so, part of the proposal mentioned, trying to avoid embarrassment, I think the word was, or criticism. Personally, I don't think that word avoiding criticism should be anywhere in that bill. I mean, I think you all know what you signed up for when you go into public service, and these are public officials and public documents, public records, and so the word public is all over them. But, this bill would eliminate that word pretty much. And so it's really one of the bad things that would come from it as well is, public record can give somebody a sense on whether you should keep on looking if there's something there. Without that, you're going to have a lot of probably frivolous lawsuits by people trying to get the records through the discovery process. And so those same people that are trying to maybe avoid the hassle of fulfilling the public records requests are going to have to deal with a lot more lawsuits coming their way. And whether they're frivolous or not, the judge is going to have to spend the time to dig in. And maybe they're going to have to demand this record that's in dispute just to find out whether there's a there. And so by having a robust public records system, we avoid a lot of that problem. And, for those of us that are critics of the government, which is, I think, all of us, it's our job to do the homework, and this bill would prevent us from doing that. Thank you.
Thank you, sir.
My name is Billy Broussard. I appreciate y'all giving me time to speak today. I'd like to point out something that Senator Miller brought up about the purpose of our insurance. The Attorney General mentioned she doesn't have an answer, and the congressional delegation can't find an answer to why FEMA. Well, I can tell you, because this bayou just to say this area that was flooded back in 2006 after Hurricane Rita was a year later. From my understanding, 600 people flooded. And y'all all know right after a disaster, you're there with your constituents going, what happened? Why did you flood? Well, I cleaned the bayou. I didn't know. I got the contract. We cleaned in the bayou. I talked to constituents. They say, do you know why y'all doing this? We're not exactly sure. We're just cleaning up behind the hurricane. We find out that they've told all these constituents, well, the reason you flooded was all because of Hurricane Rita debris that was put in the bayou. Well, I'm telling you, I cleaned the bayou, and it was 10 times the debris than what FEMA originally estimated to be in the bayou. Now, I will let you know that in regards to public records, Senator Mills was helping me. He was the senator at the time. I sent emails to the parish telling them the reason why I wanted public records. I got a judgment against me and my senator, or just to say my senator today would want to help me with this. Not that we can't get the public records, but we can't even communicate with these people in the parish, police, jurors, etc. And the thing is what's very interesting about this particular case is we don't want to admit sometimes why we're flooding and why we have these problems, but it's neglect. Nobody wants to, say, it's the municipality that's not doing their proper maintenance. And through this, this was a project that I never seen so much cover up in my life. And I'm talking about at every level. GOSAP, their contractors, the parish, the drainage district, their attorneys, all of them. And interesting, the person that knows a lot about this was my original attorney, who is now our governor. And guess what? I promise you, at the time, he said, I'm willing to speak or answer any questions. I promise you, I would love to be able to sit in the office with the governor, who I have no ill will to. He's actually my cousin, and I love him very much, and I want him to be protected as much as possible. But when constituents at that level, and not just this 600 people that are flooded, but how often do we have disasters in Louisiana? All the time. I've been cleaning up behind disasters. I'm an arborist. I cut trees, so I do things to prevent disasters. But on the back end, I cleaned up a lot after storms. And I'm telling you, all this stuff behind the scenes, I mean, think about it. For no one to have an answer to why FEMA upped the rates, FEMA's not idiots. They just don't, they have a big back and they just don't throw anybody under the bus. They just raise the rate and say, deal with it. But it's because of so much fraud, waste, and abuse and misleading the public about the real reason they're flooding. We have to have a better system than just turn around, don't drown. So, I mean, I have so much information that I obtain through public records requests that would, and I would love to be, trusted. They say trust, but verify. I have the evidence to prove that I can verify everything that I'm saying. So, this bill, I want the governor to be protected, trust me. But all these municipalities, to be able to cover this type of behavior up, I don't see why anybody would want to support this. It's not fair to the constituents. Thank you.
Thank you also very much for coming to testify. The last three individuals who wish to testify would be Robert Burns, C.J. Matthews, and Carl Brown. If the three of you would come, that would conclude the opposition.
Thank you, Mr. Chairman, and I'll be brief because I think the points have been pretty authoritatively covered. I am Robert Burns. I founded the video blog Sound Off Louisiana. Several of the senators who have been behind there have been profiled, including you, Senator Fields. I'm sure you know that. But at any rate, I formed this blog 9 years ago, and I will echo the same sentiments that Lee Zurich said. I have made, not nearly as many as him, but I have made an enormous amount of public records requests, especially on Louisiana State Police. The deliberative process has not been asserted one time. So this is doing something. It's got to be. And all I can say is I've had numerous features that I have been able to produce, and it's a video blog because of the public records. I'm flattered that Lee Zurich has taken Sound Off Louisiana footage, gave the credit for it. I'm flattered that Chris Nakamoto has taken Sound Off Louisiana footage and given credit for it. I don't make one dime. There was a mention about selling newspapers earlier. I make nothing, zero. It's a money-losing operation. I do it strictly because I love this state. I was born in this state. I've resided my entire 60 years in this state. But the reality is this state is perceived as corrupt. I mean, it's that simple. So here we are looking at enacting something that will make it even more difficult to detect the corruption. So you're taking one of the, I'm sorry, you haven't voted. If this passes, would be taking one of the little small David slingshots that we've got to try to go up against Goliath and removing it. And I just think it is enormously harmful. I personally don't think it was a mistake that, as Senator Jenkins pointed out, multiple objects here. Nobody's going to want to vote against protecting the governor. And so it puts all of y'all, and if it goes to the floor of the Senate, it puts them in a precarious position. And I can only say that I don't envy being any one of y'all. I don't envy the other members of the Senate, because I believe what has happened here is that you've been put in to have to make a choice between alienating a brand new governor and his honeymoon period versus alienating an awful lot of constituents. With that, Senator Fields, thank you for the opportunity to address.
Thank you very much for coming to testify today, sir.
I'm C.J. Matthews. I'm a retired captain with the Ascension Parish Sheriff's Office. Let's talk about law enforcement for just 1 second. Who polices the police? I'll tell you right now, nobody. All you got to do is look at the Robert Greene incident, and there's many others out there. When you are the chief law enforcement agent for a parish and you decide that you don't want to put somebody in jail who committed a crime, who do you go to? Is it the state police? They're not going to do anything. Is it the AG's office? They're not going to do anything either. You got to give the public the ability to get that information. Minus that, you are violating the public's trust. Enough said.
Thank you very much, sir. All right, that concludes the testimony in opposition. Yes, sir. Representative, did you fill out a card? Because where is it?
But I was in.
Okay, I may have called your name, and please come and try to make it brief.
I will.
Because
I will make it brief.
yes, sir. Please identify yourself for the record, and you may proceed.
Hello, members. I appreciate your time. I know it's been a long day. I am Barry Ivy, a citizen. People said in House and Governmental Representative Ivy. I want to make a distinction. It's former Representative Ivy. I do not want to be accused of being a state legislator in this term. So, with that said, I oppose this bill for several reasons. I wasn't able to listen to the testimony by Mr. Sternberg, but I'm sure it was perfectly legally sound arguments. And so I'm not going to talk about the details and the nitty gritty. I just want to bring into some focus a more practical perspective. This bill does create a paradigm shift in executive branch public records. This bill will limit the access to public records in a manner that only allows the people to be aware of what their government did after they did it, and ultimately prevents the people from accessing records to find out how government did what it did. And so, to me, that is a dangerous shift. You know, everybody campaigned recently this last election cycle, including the governor and many legislators. And for people on the right, you know, the use of the term conservatism or conservative, it's a central theme in their campaigns. I saw it, you know, everywhere. And so during the gubernatorial campaign, Governor Landry did it and many others. And so I would like to read a brief excerpt from an article written by Glenn Sproverio and published on the Imaginative Conservative website on May 15, 2017. It says, "The genuine conservative is not motivated by fear, avarice, or power. The very constitution of his being is directed toward the perfection of his soul." And so it says, in this modern usage, the word ideology is not synonymous with benign philosophy. Rather, its contemporary meaning invokes a messianic, almost religious veneration of abstract ideas that promise perfection in the political order. A secular fanaticism parading under the rubric of genteel intellectualism. Ideology cares nothing for the soul and scoffs at the idea of a spiritual order beyond the reach of state authority. Under its dictatorship, everything must succumb to the omnipotence of an abstract idea to which all individual and social actions are subordinated. You know, Senator Cloud said something earlier, testifying to Governor Landry's, transparency. But I recall, and I don't know if this ever happened before, but former, then AG Landry sued a reporter for making a public records request. I mean, in her personal capacity. And this is the same person who supports this exception to public records. And so I'm sorry, I don't trust government. The people don't trust government. We had an election, the last election cycle, 25% turnout in the general election. Why? Because people find this institution to be deplorable. And they don't feel like, why should we show up? And so what do? In 5 days, we make massive changes to policies that affect every single person in the state. And we do it in 5 days under, emergency declarations. And we're told that, we need to be able to access some of these records because maybe you've only got 5 days to intervene in what's being pushed down the pipe. So, thank you.
Thank you, Mr. Ivory. All right, that's it. Senator Cloud, come and close on your bill, please. All right, is there a motion from the, where's Senator Cloud?
She's right out in the hall. She's right out in the hall.
Senator Cloud.
There she is.
All right, briefly close on your bill, Senator.
I have a 3-page dissertation I'd like to read on the bill. Look, members, everyone that's here in the room and everyone that's watching across the state, if you've seen me walk in and out of the room, it's because I'm having dialogue about the implications of the bill, because I don't want to do harm. I want to do good. That's what my people sent me here to do, and that's what my Lord and Savior expects of me. So what I would like to ask, because we are halfway through, and the Senate President has asked for us to try to move the bills through committee, is to move the bill through the committee with my promise that I'm not going to move the bill on the floor until I get it in a better posture that we could all kind of coalesce around. Again, because we don't want to do harm, we want to do good, and we need to check all those boxes like Senator Carter said earlier. So that's my commitment to you, is to continue to work on this. If it'd be 2 weeks ago, I would have just kept it in committee, but because we're knocking on the end's door and a lot of the House bills are moving over now, I think it would bog all of you down for me to just hold it and then go through another 3 or 4 hour discussion here when it's only the first stage of the process.
All right, members, you've heard the testimony of Senate Bill 482 by Senator Cloud. What's your pleasure? All right, there being no motion.
Make the motion to move things.
All right, Senator Klein-Peter moves that we report Senate Bill 482 as amended. Are there? Yes, Senator Carter.
Thank you. Senator, I certainly am willing to work with you between here and the floor on this, but I can't vote for it in its current form. So I'm going to object now, but I do look forward to working with you on it for all the reasons that we heard today and my reading of it in jurisprudence and things of that sort. So I do want to object, but I also look forward to working with you on it.
Yes, sir. We'll be looking at narrowing it down and making it explicitly clear that people have access to what they need.
And I think there's very little, if any, pushback regarding the security piece for the governor's family. But the other aspects of it, we obviously have to work on it. Thank you, Mr. Chairman.
All right, thank you, Senator Carter. Senator Klein-Peter.
Thank you, Mr. Chairman. Yes, I just want to, I agree. I think we have some concerns. I don't want the bill to stall, though, and then have us go through another 3 or 4 hours. But I do look forward to working with you to see what we can do to make this bill a better bill. Thank you.
Thank you.
All right. There's a motion on the floor to report the bill as amended. There are objections. There are objections. When the secretary called the roll, if you are for sending the bill to the floor, you would vote aye. If you're against, you would vote no. Secretary, call the roll.
Senator Miguez?
Yes.
Yes. Senator Carter? No. Senator Fazy?
Yes.
Yes. Senator Jenkins? No. Senator Klein-Peter?
Yes.
Yes. Senator Miller? Yes. Senator Reese?
Yes.
Yes. And Senator Womack?
Yes.
Yes. 6 yeas, 2 nays.
6 yeas and 2 nays. The bill is reported as amended.